I bought a property and had to get 3 family members involved to show affordability. We drew up a contract with property attorneys that each person needs to contribute in order to get a share in the property. I have been paying the bond for the last 10 years. Another family member, pays the rates, and the remaining 2 family members have not contributed at all. Now, these 2 family members who have not contributed are demanding I pay them out for their shares in the property. The attorneys who drew up the contract state that this is a criminal matter and not a property case. How can these individuals, these family members, claim a share without having contributed anything toward the property? Cilna, how can we help this gentleman?
Sure. That is I do not see the criminal law element in this stutter. That's where that stutter came from. Yeah. Okay. I'm glad you say the same thing. Okay. So I think, Bruno, you so perfectly just said, to explain the difference between criminal and civil is an academic thing, and it's going to be super boring, but I can't see a crime here. So any crime must have specific elements. So the best I can think of that this attorney might think of would be fraud related something, but I don't see that every single element of every crime, and criminal lawyers don't sue me for this one. The last time I did anything on criminal law was probably at varsity, so I'm lying once in my articles as well. But every crime, unless there's now 3 exceptions that I'm not mentioning, must have an element of intent or severe negligence or something like that. And in this particular situation, the fact that the parties went to an attorney to draft up a contract means I can't see that anybody tried to do anything sneaky and intentionally or negligently attempting to harm another financially, obviously. So I can't see a criminal element, yeah, I definitely can't. So let's just move to the actual contract. Every question that we get asked in this particular one relates to that contract. And I think that's what makes it difficult to answer, because we can't see the contract. We don't know what the provisions were. So every contract that you draft, be it a offer to purchase, a joint venture agreement, a partnership agreement, whatever the case might be, you will have rights and obligations of the parties. And everything must be set out clearly. If you meet the essentialia, so the specific terms of a specific type of contract, for instance, a lease agreement, if you can see this is an agreement where property is being let to somebody, that the tenant will receive undisturbed and use and enjoyment of the premises for a temporary time period, and they will pay rent. It is a lease agreement, even if it's not called a lease agreement. And from that document, you will have both incidentalia and naturalia. That doesn't have to be written in the contract. So there are terms flowing from the nature of the contract. Now, because we haven't seen the contract, and I can't even guess, I'm guessing it's going to be either an offer to purchase that had a baby sort of with a joint venture type agreement, or a partnership agreement. It's going to be something like that. But without seeing the contract, I won't be able to determine what contract we're talking about. And for that reason, I won't be able to tell you what obligations each party had. Ideally, the fact that you say a property lawyer drafted this, it does tell me they would have thought of everything, and hopefully they did, and said, party A must do this to receive this. Same story with party B, C, and D. And if the contract says you have to contribute X amount, you have to pay the rates and taxes, or you have to pay the interest on the bond, or you have to maybe not contribute money. Maybe you are the one that sourced the transaction and you had to find it. So you had to spend all the time and effort to secure the property. And then you are entitled to a 25% share in the property. Then you don't necessarily have to give money, and you would be entitled to your shareholding, depending on how it was done. If it was done, for instance, in a company, what is your method that you use to value the shares in the company? What is the valuation of this property at this very moment? Did they buy and add more money to it? Is the value more or less? And can the parties sell to each other? And all of that will have to be handled in terms of the contract. So unfortunately, I'm giving a very wishy-washy answer, because my answer is I can't give you an answer unless I see that contract. So my advice in a situation like that is go back to the contract. Everything should be there. And if it is not, unfortunately, it's one of those severe litigation situations where it's going to come down to oral evidence. And unfortunately, we're talking a 3-4 year litigation and extremely expensive. Bruno, am I just being blunt?
No, not at all. And I mean, we've touched on this type of question a couple of times when it comes to how important it is when buying properties jointly, that proper contracts be entered into. When a person refers to a JV, what that actually means. When people refer to stokvels or investment clubs, what that actually means. Because in the layperson's perception, some of these things are just, oh, well, it's simple. But it's not always simple. There's legal consequences. And sometimes you only figure these out when things go wrong. So in a case like this, where there was some kind of joint purchase of a property, yes, it comes down to what the contract says. Did the contract require that they perform? What does the contract say about what happens if they don't perform? How do you deal with them? Are they still entitled? Was the agreement ever cancelled by any chance or not cancelled? Can there be, this is somewhere along those lines. So it does get complicated, because I mean, sure, I'm just thinking of some of the ramifications where if the contract's still in existence, no one cancelled it, they just simply failed to perform, but no one did anything about it. The question now is, are they still entitled to their share simply by paying what their initial contribution should have been? And that's unfortunately where it starts getting to that area where it's important to have a contract, but it's also important to manage a contract. If you don't do the right things at the right time, you can't just go later and say, well, you know what, I should have canceled it. You should have canceled it, but did you cancel it? Because if you didn't, then unfortunately people still retain some of their rights even after a long period of time. And yes, it might be to your detriment, but unless you can prove that you actually suffered damages, it gets complicated.